Ashley Benefield, a former model and ballerina, finding herself at the center of a high-profile trial after being accused of shooting and killing her husband, Douglas Benefield. Claiming self-defense, Ashley's case sheds light on the complexities of domestic violence and the legal challenges that arise when trying to prove justifiable force. All this weekend on the Hidden Killers podcast, we're examining the case of Ashley Benefield, examining the events leading up to that fateful day in their Lakewood Ranch, Florida home, and the allegations of abuse Ashley made against Douglas. We're taking you to the courtroom for raw audio from the Stand Your Ground hearing of Ashley Benefield all weekend here on the Hidden Killers podcast.
Now, you've told us that he was, I think the words that you used, Mr. Benefield, was starstruck with my client, Miss Benefield.
Yes, sir. I would say that.
You're married.
Yes, sir.
Happily so.
Very happy.
How many years?
Just over 4.
All right. Do you own a weapon, a firearm?
Objection, relevance.
I'll overrule.
I own firearms, but I do not have a concealed carry permit like they did.
All right, and you're familiar with firearms from your time in the Navy, I trust.
Less from the Navy than after.
Okay. Have you ever fired a firearm inside your home? Intentionally?
Not intentionally or unintentionally.
Did your cousin Doug ever tell you that he admitted to firing?
Objection, Judge. This is part of what we were not going to get into.
So the objection is relevance?
The objection is relevance, and that there were certain complaints that this defendant made against the victim that were denied by Judge Moreland in a hearing, and this is one of those.
Okay. So is there a written agreement not to get into this, and that written agreement delineates everything?
No,
or is
but
this...
I thought we were not going to get into the specifics about the, other than it was shooting into the ceiling.
Yeah, well, I intend to stay within the 4 corners of my motion, but I think it's fair cross-examination based on what he's testified to, his intimate knowledge of Douglas Benefield.
Okay. I don't know. I don't know what the agreement was to get into or not get into. I don't know what the relevance of this is going to be. It may be relevant. It may not. But again, I don't have to unring a bell with a jury here. So for now, I'll allow it.
Thank you.
I may decide later it's completely irrelevant. I don't know.
Understood. May I?
Yes.
Have you ever fired a firearm inside your home intentionally?
No, sir.
Have you ever considered firing a firearm inside your home intentionally to intimidate your wife?
Objection, relevance of this question.
Hold on. Let the question finish. Let the question finish. Go ahead. But,
Thank you.
sir, hold on. There's going to be an objection.
Yes, sir.
Go ahead and finish your question.
To intimidate your wife into not speaking any further.
Go ahead.
And what is the relevance of whether he
I just need objection, relevance, sustained.
Did your cousin ever share that with you?
My
Objection,
cousin,
hearsay.
Overruled.
my cousin admitted both privately.
Is the answer yes?
I would like to answer your question and be very accurate, sir, like I've been all along.
I understand, however, Mr. Benefield, this is
Yes, sir.
cross-examination.
Yes, sir. He inadvertently fired a gun in his home.
No, he testified under oath that he intentionally fired.
Objection, is there a question?
Improper impeachment. Go ahead, sir.
Did
Sustained.
he ever acknowledge to you that he intentionally fired the
No, sir, he did not.
Did he ever tell you that he threw a loaded gun at Miss Benefield?
Perhaps we talked about that. I don't remember that specific event like I remember the inadvertent firing.
Did he ever acknowledge to you that he punched the dog in the face so hard that it rendered the dog unconscious?
That's not what happened in his story to me.
Were you there?
No, sir. You asked me if I talked to him.
Did he ever acknowledge to you that he punched the dog in the face so hard that it knocked the dog out?
He admitted hurting the dog, but that's not a detail I remember.
Is the answer to my question no or yes?
Would you restate the question, please?
Did he ever admit to you punching the dog in the face so hard that it knocked the dog unconscious?
No, sir.
Did he ever tell you that he regularly carried a loaded firearm?
Of course.
All right. And to be clear, it was a firearm that was also cocked. All that was necessary was to pull the trigger.
I don't remember that detail, but I'm sure that he carried it appropriately or he wouldn't have carried it.
Okay. You don't know whether he carried it racked or not?
No, sir.
Did he acknowledge to you that he placed a tracker on Miss Benefield's car?
No, sir.
Did he acknowledge to you that he was caught at night by a neighbor peering into
Objection,
Miss...
Judge. Counsel is testifying just to find out if this witness has the information.
Correct.
If she
So-
wants to call a witness, fine.
Your Honor, he's testifying.
Hold on. The way cross-examination works
Yes, sir.
is that the attorney is allowed to ask his question.
Yes, sir.
Generally, it's going to be yes or no. If you can agree with it, you agree with it, and then you agree with it in total,
Or not.
or no.
Yes, sir.
And if it's a question about do you know or you don't.
Yes, sir.
And State, I understand what you're saying on the counsel's testifying. That's another issue, obviously, if there was a jury here and so forth. With me, I'm not going to be influenced by the question. The witness can say, yes, that's true, or no, it's not. I know that. I don't know that. So go ahead.
Thank you, Judge. Did he admit to you and acknowledge that he was caught by a neighbor of Miss Benefield's at night, standing in the neighbor's yard, peering into Miss Benefield's window?
I don't remember that from him.
Is that something that you think you'd recall?
Yes, sir.
Is that something that you would expect of the Douglas Benefield that you knew as well as you did?
It's a possibility, not a regular habit of his.
Did he acknowledge to you, Mr. Benefield, punching holes in the drywall of their home out of anger?
I'm aware of one, not many.
And finally, did he acknowledge to you beating up his first wife, Renee, on their honeymoon?
I'm not aware of that.
When he lived here in Bradenton, Mr. Benefield, I want to be clear about something. At no time, to your knowledge, did he live in the same residence as Miss Benefield?
I know that they were on the lease together in the final apartment, but I don't know if they ever were in the apartment together, but they were on the lease together.
Okay. So my question to you is, did he reside in a separate apartment here in Bradenton?
He had an apartment in Bradenton. Yes, sir.
I don't believe I have anything further.
Yes, sir. Redirect.
Your Honor, give me one moment.
Yes, I was going to say, if you need a moment, go ahead and
Yes.
do that. Hold on one second.
Your Honor, something for the court to consider at a later time. If the court would take a look at 90-806 of the Florida Evidence Code regarding hearsay, it states that once hearsay has been admitted and allowed by the court, the opposing party is entitled to move into evidence any testimony of the witness referred to, the non-testifying party, that exists. So in other words, during the state's examination of Mr. Benefield, wherein hearsay statements were allowed, the defense is entitled under 806 to move into evidence the entire statements of any prior statements made by Mr. Benefield, the deceased. If the court would take a look at that rule, I'll address it later on.
Okay, so the doctrine of completeness? The doctrine of completeness?
Yeah.
For that particular, each particular statement?
It's actually separate from the doctrine of completeness, but pretty much the same thing. It basically says when hearsay is allowed, the hearsay statement in any capacity or any statement of the non-testifying witness may be admitted into evidence by the adverse side.
I guess it'll just depend on what the statement is and when it was made and the relevance, and sure.
Yes, I'll address it with the court at a later.
Okay. Yes, ma'am, redirect.
Just for the record, Judge, I completely disagree that that's what 9806 says. And in my direct examination of Mr. Benefield, I was very specific to only get Ashley's comments, not Doug Benefield's comments with reference to hearsay. So just that would be my response to that. So the defense asked you about this punching a dog issue.
Yes, sir.
And,
Yes, ma'am.
and you said that's not the story I got. What was the story you got?
The story I got was that Doug was sitting on one of his chairs with an ottoman. He always wore short shorts, bare-legged sandals, just like the night he was killed. And the dog jumped up in his lap because the dog was I picked up the dog after his killing, so I'm very familiar with Sully. Big dog, big nails, jumped up in his lap, and he was frustrated, and it hurt. Aggressively pushed is one way, is what he told me.
Okay.
He admitted that was more than he wanted to do to the dog, but it was due to his frustration at the time. He pushed the dog off of his lap because it was cutting into his legs.
So at no time did he say he punched a dog?
No, ma'am.
At no time did he say that the dog went unconscious?
No, ma'am.
And the defense asked you if you were aware if Doug told you that he put a tracker on the defendant's car. Were you aware of that?
No, ma'am.
Okay. The defense also asked if you knew about Doug punching a hole in the wall.
I knew about one punch.
And what was the reason for that punch?
Frustration.
The defense asked you if Doug regularly carried a firearm. Did Ashley regularly carry a firearm?
Even the first night she met him in front of Secret Service in the area.
Okay.
Yes, ma'am.
So did she have a concealed weapons permit?
I understand she does.
And did Doug have a concealed weapons
Yes, ma'am.
permit? No further questions.
All right. Did you have any further questions before we let this witness go?
Yes, one. Mr. Benefield, where did you obtain the explanation about what happened to Sully by your cousin?
Both from Ashley and Doug.
Your Honor, now, again, I would direct the court's attention to 806. And briefly, if I may, Your Honor, I'll read to the court why I believe it's appropriate. Attacking and supporting credibility of declarant. When a hearsay statement has been admitted in evidence, credibility of the declarant may be attacked, and if attacked, may be supported by any evidence that would be admissible for those purposes if the declarant had testified as a witness. Evidence of a statement or conduct by the declarant at any time inconsistent with the declarant's hearsay statement is admissible, regardless of whether or not the declarant has been afforded an opportunity to deny or explain it. Okay, so I think any statement inconsistent with this witness's repetition of a hearsay statement by Douglas Benefield is admissible. And I would suggest that the exhibits to our stand your ground motion clearly apply to that.
I don't know which exhibits we're talking about.
I don't either. And Judge, I would argue that the only person that elicited hearsay was defense counsel. So defense counsel cannot elicit hearsay and then try to impeach the hearsay that he elicited. So I would object and disagree with that.
Yeah, I don't know what are we?
Judge, Your Honor may recall that during the direct examination by Ms. O'Donnell, Mr. Benefield related conversations that took place with the deceased, Douglas Benefield. And specifically, there was a hearsay objection. The court overruled it and allowed it. That opens the door to 806, Your Honor.
Right, I didn't hear argument on it. Which specific statement was it?
I believe, among other things, Mr. Benefield testified to everything relating to the ballet. I believe he testified to statements about how enamored Douglas Benefield, the deceased, was with Ashley Benefield. Those hearsay statements alone, Your Honor, open the door to 806, so that any statement by Douglas Benefield that is inconsistent with that testimony is admissible.
I don't remember any statements where. You know what? This would probably be better, sir. We're talking about your testimony.
It's okay.
I'm going to excuse you to the
Yes, sir.
hallway.
No worries.
The rule of sequestration has been invoked.
Yes, sir.
That's a rule here in the state of Florida, probably other places too. That says once you're called as a witness, you're summoned as a witness, you're not to discuss your testimony, the questions asked, the answers given with anyone at all until you're released from your subpoena or the hearing or the proceeding is concluded.
Yes, sir.
So that rule has been invoked. So when you're outside, you can't talk to anybody.
Yes, sir. I understand the rule and I'll follow it.
All right. Thank you, sir.
Sure.
We'll call you back in as soon as we can.
Yes, sir.
There is more to come in the Ashley Benefield Stand Your Ground hearing. We're bringing it to you all weekend long here on the Hidden Killers podcast. Press subscribe so you don't miss a minute of courtroom coverage. I'm Tony Bruschi. Stay with us.